In this video, I'll show you January 14th, 2021. An unidentified Harnett County resident reported her dirt bike as stolen to the Fuqua-Varina Police Department in North Carolina. 16 days later, the resident contacted a seller through Facebook, who she believed was in possession of her stolen bike. The resident and her boyfriend arranged to meet with the seller to verify that it was the bike that had been stolen from her, and were able to positively identify the bike through its vehicle identification number. The resident then contacted the Fuqua-Varina police and informed them that she had located her bike and gave a brief description of the seller along with his name, Malcolm Ziegler. 2 officers were then dispatched
to Mr. Ziegler's home to investigate a possible case of felony possession of stolen property.
Okay, what's your name? Malcolm?
Yes.
What's your last name? Malcolm Ziegler?
Yeah.
Okay, you got your ID on you?
No, I do not.
Okay.
But that wasn't us riding. We haven't read it all this week.
Where do you stay? You stay here?
Yeah.
Okay.
I haven't read it all today. He could have just came by here.
Who's that guy? Who's that guy running down the street?
That's his friend. They say somewhere up there.
Okay. Do me a favor.
Go ahead and put your hand back for me, okay? Within minutes of arriving on the scene, the initial responding officer decided to place Mr. Ziegler into handcuffs without verifying any of the facts associated with the encounter. The question of whether or not Mr. Ziegler was legitimately detained is a major aspect of this encounter, and it is important to examine the court's perspective of what constitutes a lawful detainment. The Fourth Amendment was intended to protect citizens against arbitrary arrests and unreasonable searches, and the Supreme Court has routinely verified its intention through various rulings, and held that some objective justification must be shown in order to validate any seizure of a citizen. In the 2001 case of Atwater versus Lago Vista, the Supreme Court held that although the case involved, quote, gratuitous humiliations imposed by a police officer who was at best exercising extremely poor judgment, case by case, analysis of the legitimacy of any given detainment should be relegated to statutory rule rather than constitutional scrutiny. The court reasoned that if every detention could be challenged on the merits of a amendment violation, quote, lest every discretionary judgment in the field be converted into an occasion for constitutional review, and held that so long as probable cause was present, a detainment is justified regardless of the severity of the crime. In the 1991 case of County of Riverside versus McLaughlin, the Supreme Court upheld the notion that individuals subject to detainment or arrest are entitled to a quote-unquote prompt judicial determination of probable cause, and upheld a previous ruling that limited the time allotted for a prompt determination to 48 hours. Hours from the time of the seizure. Working in tandem, the Atwater and McLaughlin rulings essentially provided officers with nearly unbridled discretion to determine whether to make an arrest or issue a citation on any given charge, even if the charge is as minuscule as a traffic violation, and hold the suspect for up to 48 hours with little to no recourse. The court also reasoned that an officer's true intention was not a prevailing factor in determining the legality of a detainment or arrest in the 1996 case of Wren versus United States, and that the legitimacy of a detainment depends almost exclusively upon whether or not probable cause existed at the time of the detainment. In an effort to properly determine when a seizure occurs, the court held that the appropriate inquiry is, quote, whether a reasonable person would feel free to decline the officer's requests or otherwise terminate the encounter. In the 1991 case of Florida versus Bostick, according to the Bostick ruling, it is clear that Mr. Ziegler was not free to decline the officer's requests or terminate the encounter, and it is likely that a court would determine that he was officially detained once the officer placed him into handcuffs. However, the officer failed to validate any of the claims made by the complainant before deciding to detain and search Mr. Ziegler. And as mentioned earlier, probable cause is a necessary element in determining whether a detainment is valid. At the moment of Mr. Ziegler's detention, the officer had no way of objectively knowing whether he was in fact in possession of stolen property and was operating purely on the hearsay and speculation provided by the complaining party. Given that the officer lacked any objective substantiating evidence at the time of Mr. Ziegler's detainment, it is entirely possible that a court would rule the detainment unlawful.
That I bought it?
Yeah. We'll get all that taken care of, man. But what I need to do is just hang tight for me right here, okay?
Gosh, what did I do?
Just hang tight for me right here, okay?
The officer leads Mr. Ziegler to his patrol vehicle and searches him. During the search, Mr. Ziegler informs the officer that he is a minor, and the officer decides to place Mr. Ziegler into his patrol vehicle while another officer makes contact with Mr. Ziegler's father in an attempt to locate the bill of sale. During the search, the officer broadcasts a code 1095 to dispatch, which is widely accepted to mean that an officer has a subject in custody with the intention to perform a formal arrest.
Well, I'm going to work on getting you out of those soon, okay? Just keep cooperating with me. I appreciate it. And we'll get everything squared away.
Stole before. I don't.
Okay. And sir,
I can try to find the bill of sale. I have
sir,
a lot of
and I'm not saying that you stole it. Right now, what we've got is we just got a stolen motor vehicle. We're not saying that you stole the vehicle. Okay, I'm not saying that at all. Okay,
Yes, sir.
but it still
Was a crime to be in possession of a stolen motor vehicle. The officer informs Mr. Ziegler that they are not accusing him of committing the act of stealing the dirt bike, but that being in possession of stolen property is still a crime. Section 14-72 of North Carolina's General Statutes covers the crimes of larceny, receiving stolen goods, and possessing stolen goods, and states that, quote, the receiving or possessing of stolen goods of the value of more than $1,000 while knowing or having reasonable grounds to believe that the goods are stolen is a Class AH felony. According to the language of Section 14-72, the offender must have had prior knowledge or a reasonable indication that the property in question was stolen in order to be found guilty of the violation. And in the 1953 Supreme Court of North Carolina case of State v. Brady, the court clarified that in order to be convicted under Section 14-72, it must be proven that, quote, A, the stealing of the goods by some other than the accused, B, that the accused, knowing them to be stolen, received or aided in concealing the goods, and C, continued such possession or concealment with a dishonest purpose. However, that does not necessarily mean that an individual cannot be arrested without the officer first proving that they had such knowledge. The burden of proof rests upon the state, and it is often difficult to prove whether or not a suspect had knowledge of the item's history prior to obtaining possession of the item. As mentioned before, an officer's arrest must be based on objective facts that led them to believe that the individual may have had such knowledge, and without evidence to prove that the item was obtained through a legitimate transaction, a court would likely find such an arrest to be reasonable in this interaction. Mr. Ziegler offers to show the officers a bill of sale to prove that the dirt bike was purchased through a legitimate transaction in good faith, which would dissolve the necessary clause of possessing the bike with criminal intent. So he's talking with your dad right now. I can show you if you can go. I can go on my phone. I can show you exactly. Okay. Hey, how are you doing, sir? Hey, Dan, I need that bill of sale. Reason all this is going down, that vehicle's been entered a stolen international crime information center. Do you have the bill of sale by any chance, sir? I don't know where it is. It's either in my room or in the garage. You gotta tell me where it is now. I saw you. I'll sign it, but what did you know? What is the guy's name to show you the bike? I think it's telling me something. If you go on my phone, you can look at Facebook profile. Tell me what the bill of sale is. Go from the counter and see if it's on there. What counter? Inside the kitchen, the first one that has all where you put the mail at Mr. Ziegler's father, and one of the officers go back to the house and begin searching through various bills of sale to locate the one associated with the transaction involving this particular bike. While Mr. Ziegler's father is searching for the correct bill of sale, two of the responding officers discuss the legitimacy of Mr. Ziegler's detainment.
Hey, is he detained or 1095?
From what I heard, 1095, and that was before I even verified the VIN.
Okay.
But
That's my first thing I asked.
that's what now I'm not 100% certain, but I believe I heard essentially 1095 before I was even able to verify the VIN.
Upon clarifying whether Mr. Ziegler had been detained or arrested, one of the officers confronted the initial officer about his decision to handcuff Mr. Ziegler.
Hey,
Is he detained or is he...
he's detained right now because he's 14.
He's 14?
Yes.
Okay.
So I already explained to him he's detained right now. I told him that
So why is he detained?
because that's a stolen motor vehicle.
Okay. So,
I mean, Diggs verified the VIN number, right?
is that before all that you verified before you...
I detained him and then we
Okay, that's why I
verified
asked if he was 1095 or detained.
He's detained.
Okay. So, obviously he's a juvenile, right?
Yeah.
You're not charging him with larceny of a...
Nope.
Okay, because obviously that didn't happen.
Yep.
Here. So, worst you have is what?
Possession of a stolen motor vehicle.
Which is, you gonna think you get secure custody and all that?
Probably
Or a
not.
petition? Alright. You're 14, me personally, you ain't going nowhere. You're here with what, Dad?
Mm-hmm.
Ain't no sense having him sit in the car with handcuffs on.
Okay.
You ain't, if he was 18 and you might be taken to jail for possession of stolen property,
All right.
different.
The confronting officer urges the other officer to consider the practical implications of his decision to detain Mr. Ziegler and points to the distinction between the protocol for adults and minors. There are vast discrepancies between how the law and legal process applies to adults and minors, and arresting a minor generally invokes a much more thorough and determinative process than arresting an adult, according to a guide assembled by Youth Justice North Carolina, which is an organization of law and policy experts focused on the juvenile justice systems in North Carolina. The juvenile court process begins when a complaint alleging that a child is a quote, UN quote, juvenile delinquent is filed with the juvenile court. A juvenile delinquent is any child ages 6 to 15 who is alleged to have committed a crime or infraction, and individuals who are 16 or older go directly to the adult court system, not the juvenile system. Juveniles may be taken into temporary custody only under one or more of the following conditions. 1. A law enforcement officer witnesses the juvenile commit or has probable cause to believe that a juvenile committed a serious crime. 2. A law enforcement officer or court counselor has reasonable grounds to believe the juvenile is beyond the disciplinary control of his or her guardian. Or 3. The juvenile escaped from a residential facility. The person who takes the juvenile into temporary custody must notify the juvenile's parent, and a juvenile cannot be held for more than 12 hours or 24 hours if it is a weekend or a legal holiday or by a judge's order. Petitions for juvenile delinquency are processed by a court counselor and typically involve an intake meeting whereby the determination is made to either dismiss the complaint altogether, divert the case to restitution, community service, mediation, or a counseling program, or to file a petition which orders the juvenile and their guardian to go to court. If the parent is served with a notice and does not appear in court, the judge may issue a quote-unquote show cause order, which can result in the parent being fined or jailed. In this instance, the confronting officer questions whether a full-scale detainment is necessary, given the fact that the initial officer only intended to submit a petition for juvenile delinquency, and further asserts the notion that the initial officer did not have any objective basis for detaining Mr. Ziegler when he was placed into handcuffs. The initial officer agrees to release Mr. Ziegler, but also questions whether or not he would be justified in charging Mr. Ziegler with possessing stolen property anyway. And the confronting officer once again urges the officer to consider the facts of the encounter before making such a decision.
I'll go ahead and take him out. Question for you. So supposedly, I know they're working on getting the bill of sale right now. I haven't asked him 20 questions, but he's been running his mouth. He said that he got it from some guy off in Lillington, okay? My whole thing is, I know legally he can still be charged.
Yeah. If he's got a bill of sale, me personally,
Yeah.
I have grown up racing dirt bikes, buying four-wheelers. I got 3 four-wheelers at the house now.
Yeah.
I've never once had one run until I was a cop.
Yep. If basically what you're saying is if he has a bill of sale, you wouldn't end up filing the petition.
No, but I'd have him talk to Lake County and try to
Yeah,
figure
of
out
course.
who he got it from or not.
Hey, where all do you think that
You
bill
can,
of
you can
sale
step
might
out.
be at?
So you can step out. We're going to take the handcuffs off.
Yeah.
The officer removes the handcuffs, and Mr. Ziegler is allowed to enter his home where he was able to locate the bill of sale for the dirt bike. The officer explained to Mr. Ziegler and his father that as victims of a crime, they are entitled to restitution for the loss of their funds through the purchasing of an item that they were not aware was stolen. And after the owners of the dirt bike retrieved their property,
In a response to the controversy, Fuquay-Varina Mayor John Byrne called for the community to move forward from this encounter and declared that the officer's actions were standard procedure and not motivated by race in any way. At the time of writing this episode, it is unclear whether the Ziegler family will be pursuing legal action. Overall, the initial responding officer gets an F for detaining Mr. Ziegler before obtaining any substantiating evidence, exercising poor discretion by signaling an arrest to his fellow officers rather. A detainment, and for failing to consider the practical implications of his discretionary decision-making and authority. One of the most troubling aspects of this officer's conduct is the fact that even after he was confronted and corrected by the other officer and had evidence to prove Mr. Ziegler's innocence at his disposal, he still considered filing a petition against Mr. Ziegler and questioned the other officer's logic. One aspect of this encounter that was not yet discussed in this episode is that the initial officer was still in training, which is a testament to the notion that officers are often trained to focus on the criminal aspects of any given circumstance, even when innocent explanations are readily available and bear equal merit to the possibility of a crime being committed. If it had been left solely to the discretion of this officer, there is a good chance that Mr. Ziegler would have been inappropriately charged with possession of stolen property, regardless of whether he could prove that he legitimately purchased the dirt bike or not. And this interaction highlights the importance of consulting a superior before making decisions that could dramatically impact the life of an innocent juvenile. If the officer had simply afforded Mr. Ziegler the same degree of trust and opportunity to present evidence as he did the complaining party, then the fallout from this encounter could have been avoided entirely. The confronting officer gets an A+ for considering the real-world implications of his fellow officer's actions, challenging the officer on the merits of his conduct, and ensuring that Mr. Ziegler did not face any unnecessary or unwarranted charges. Far too often are officers complicit in the misconduct of their co-workers, and it is certainly refreshing to see an officer object to the conduct of one of their own. Not every encounter requires an arrest, and officers sometimes tend to lose sight of the ramifications of subjecting an individual to the legal process in favor of securing an arrest or quickly restoring peace. It is imperative that officers consider the potential benefits or detriments to the community that their actions will cause and take into account the effect their conduct will render to the individual beyond their arrest. I commend this officer for having the courage and conviction to challenge the initial officer's conduct and ensure that justice was administered to the actual perpetrators of crime rather than punishing an innocent victim for being scammed. This officer's conduct is a great example of how community policing should be practically implemented, and I firmly believe that there are strong lessons to be learned from this officer's behavior. As for Mr. Ziegler, I cannot rightfully offer a grade to his conduct because he was a minor at the time of this interaction, and it is unreasonable to judge his actions on a scale that is representative of the decisions made by fully developed adults. However, I do commend him for remaining calm and collected throughout the encounter and making a concerted effort to prove his innocence. Thank you very much for watching the video. Subscribe our channel for next video.